Hello, everyone, and welcome to Police Off the Cuff, Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, 27-year veteran of the NYPD. Very interesting what's going on the last 2 days in these motion hearings in the Brian Kohberger case. Lots of motions, lots of what we would call throwing things at the wall to hope that they stick by the defense, because there's a hell of a lot of motions. Some that this man right here, this Judge Hippler, isn't appreciating. And he seems to be a very, very reasonable judge. And in that way, he doesn't suffer fools very well either. When things are thrown at him that he finds is inconsequential, no case law, no precedent to bring it up, he doesn't take that too well. He also reduced one of the defense's witnesses, from AT&T, the gentleman who was the AT&T expert for the defense. I don't have his name right in front of me right now. And he was a little bit perturbed at that. That if he's going to call people names and make allegations, these are very serious allegations that could cause someone to get disbarred. So if it's not true, don't throw stones. Don't throw the stones if it's not true. So this is what the judge somewhat implied, and as I said, he's a very reasonable guy. But what they're setting, as you see the thumbnail up on the screen, the ground rules to this trial. And, we're in the first week of April. So we're talking about there's another 3 months before this trial starts. So they're setting the ground rules, but in no way will the ground rules be set immediately, because the judge himself has to do all kinds of research based on the motions that the defense is preparing. And are they legitimate? How should he rule on them? And that's what a judge's job is, because the defense, in doing their job, is raising lots of motions that perhaps the prosecutor, Bill Thompson, I can say not perhaps, does not agree with. What will happen with this photo here? The photo taken on the morning of the murders. Will the judge allow that to be admitted as evidence? Many people in the homicide business consider that to be almost like a trophy type picture, that he was glowing in something he had just done. That's the way it's being taken. That's the way it's being reported by homicide experts. But yet, the defense and Ann Taylor, she would love to get that picture thrown out. The bushy eyebrows, reported by one of the eyeball witnesses, Dylan Mortensen. The defense would love to get that thrown out. The bushy eyebrows. Look at that picture. Does he not, in fact, have bushy eyebrows? So these are some of the things we're going to talk about today. In no way is any of these things decided. It'll take months for the judge to decide these things. And you can bet this judge, Stephen Hippler, he's going to be 100% fair in making these decisions. So folks, hold on to your hats. Hold on to your loved ones. Hold on to your cup of coffee. Hold on to your service dog. You're about to enter true crime from a police perspective. You're about to enter the off the cuff zone. The police off the cuff zone. There has to be some common sense.
They were the ones who called 911 to get him help, and now they're calling for change.
And now a word from our sponsor, Mando Whole Body Deodorant. The thing I like most about Mando Body Deodorant is that it lasts all day and leaves me feeling clean and fresh. It doesn't quit even after the harshest heat and humidity. The fresh feeling keeps me dry and confident. No need to worry about unsightly sweat stains. Mando's starter pack is perfect for new customers. It comes with a solid stick deodorant, cream tube deodorant, 2 free products of your choice like mini body wash and deodorant wipes, and free shipping. As a special offer for listeners, new customers get $5 off a starter pack with our exclusive code. That equates to over 40% of your starter pack. Use code POLICE, POLICE in capital letters at shopmando.com. That's shopmando.com. Please support our show and tell them we sent you. Smell fresher, stay drier, and boost your confidence from head to toe with Mando. Joining me today to discuss all of these emotions and more is retired NYPD Sergeant, professor at Albertus Magnus College in Connecticut, attorney. Welcome to the show, Professor Mike Giri. Welcome, Mike.
Bill, good afternoon. Good to see you. Thank you for having me on.
You know, Mike, these are these hearings, these motion hearings. There's a lot of information in there.
Oh yeah,
and so much that, wow. Do you think a judge really likes to get thousands of pages of motions that he has to rule on before these cases go to trial? And not just rule on them, but he's got to do a hell of a lot of research to make sure that he rules correctly. Because after all, this is a death penalty case, Mike.
Yeah, Billy, this is probably the biggest death penalty case in Idaho in maybe decades, perhaps, at least decades. So, Judge Hippler, he's a fair, but he's a stern judge, and that's what you want. He does not appreciate getting like 75 motions all thrown at him at one time. And he probably knows, because he's probably practiced law as an attorney himself. And Ann Taylor was a prosecutor. Now she's a defense attorney. They know the effect of this on a judge. A judge may just sit there and get a little bit aggravated and get a little testy like he did. But she knows, Ann Taylor knows, just like the Bill Thompson, that there's probably only a couple of really important motions there that she's hoping to get approved, and before they go to trial, and the rest she probably figures he's going to rule against me. But she's doing her due diligence, she's doing her ethical obligations, zealously advocating for Brian Kohberger. And I do not think that Judge Hippler appreciates the number and the type of some of these motions that Ann Taylor made.
Well, I also believe, Mike, that sometimes the attorneys will throw out a motion and have no precedent, no case law, and they're sort of making up a reason for it. And the judge, I could see when I watch the hearings, he does not find that amusing at all. He's, the old expression, he doesn't suffer fools well. And when they try to slip it in, he gets annoyed. What is the precedent for this? What is the case law for this? What is your reference for this? And on several of the motions, they couldn't say why. And he was annoyed. Yeah,
Bill, if it's one thing, if an attorney says, look, I want to make a motion to exclude this sort of evidence because it's very, very prejudicial to my client, whatever happens to be, like, for instance, the test that he had written, the final exam and things like that. Okay, I understand it. And it's not really an unprecedented kind of thing to do. You want to get rid of some of those things that are really prejudicial and kind of cloud up the main issue of who actually killed these 4 young people. And so people understand it. Judges understand it. Attorneys understand it, both defense and prosecution. But when you make a suggestion, like, say, for instance, about make a motion about the FBI using a particular crime lab to do the IgG, investigative genetic genealogy, and you want to have it thrown out, you better have some sort of really strong, or even passably strong, foundational reason for suggesting it. When you go out on a limb and you're so far out on a limb that you have nothing supporting you, the judge finds that annoying. He doesn't probably appreciate it, and she knows she's not going to win. But you never know. She's hoping on a particular day at a particular time, the judge might say, "Yeah, maybe I'll think about it or whatever. But getting shot down by Judge Hippler, he's not the kind of person who looks like he himself is going to extend any undue privilege to the defense that he would in any other case normally do. He's going strictly by the book. He's protecting the state, and he's also and ruling fairly using the rules of evidence. But he is not an activist judge that's going to go out there on a limb and give Ann Taylor a lot of what she wants.
100%. This is from the Today Show, going to the motions meetings.
Hearing before a judge in Boise, Idaho, answering some key questions about what evidence jurors may see when Brian Kohberger's murder trial begins in August. The hearing leaving some questions open, like who, if anyone, can testify to Kohberger's alibi.
Who's going to say he was out driving around looking at the stars?
While also raising some new questions, including Kohberger's attorneys suggesting they've identified another suspect.
We came across a tip that would appear to be an alternate suspect, and we're trying to work through that as rapidly as we can.
The father of victim Kaylee Gonzalez.
I just wanted to say one thing. They came across a tip. Now, every major investigation, police departments have tip logs. I will personally tell you that 95% of those tips are absolute nonsense. So when a defense attorney says they came across a tip that could potentially be another suspect, I mean, yeah, you have to look at it. You have to investigate it, but it's not all that believable, Mike.
Yeah, and in this case, if she's going to say that there is an alternative theory, an alternative killer out there, the judge is not going to just allow her to throw that out there, to suggest it without some sort of foundation, which would make it kind of a reasonable statement to make to a jury. So therefore, he's told her that if you're going to sit there and have an alternate theory that you're going to put out there to the jury, you better name somebody. You better have something that your people investigated and kind of showed that, yeah, it is physically possible. You better come up with something. And if you're not, you can't just suggest it. Oh, yeah, there's an alternative theory. There's people on that list and they were never investigated properly. The judge is warning her, you better have good, foundation to support that allegation. And you better be prepared to name at least one name that you say, because if you don't, he's not going to allow that. That's
Mike, that is only fair. That is only fair because,
right?
Or else the defense could just, bring up doubt with something there's no basis in truth in.
Exactly.
So if a judge didn't rule in the favor in this instance for the prosecution, the defense could, bring Mickey Mouse in and say, oh, this is a suspect.
That's right.
They have to, as you say, provide a foundation if they're going to name a suspect. Let me go back to the
reacting to that theory overnight.
The new strategy is going to be, what if it's this guy? What if it's a neighbor? What if it's that guy? So it's just more signs of desperation.
At times, the hearing turning fiery, with the judge appearing skeptical of some of the defense's hundreds of pages of requests.
You've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis. Zero.
The judge has not decided.
Well, he's referring to a gentleman who is the defense's expert witness on cell phones, and his name is Cy Ray. And apparently, the prosecution did not get those records from AT&T, and they stated that. And this expert witness for the defense basically called the prosecution liars. And the judge took that very seriously and did not allow that disparagement of Bill Thompson to go unchecked, Mike.
Yeah, he said to her directly, look, he wrote a report to you. You then included his words, word for word in your motion, basically saying you have adopted your expert witnesses, argument that Bill Thompson has violated his, oath under, all kinds of canons of ethics as a prosecutor and as an attorney. If that would be true, he would be subject to censure. He'd be subject to losing his law license. You better have a foundation for that other than somebody's word. Bill Thompson was in this courtroom. He said, we have not gotten those records, and we don't have them. And so if you don't believe it, you've got a problem. He was really mad at Ann Taylor for saying that, because she adopted some quote unquote expert's opinion about what he thought what records would be given to the prosecutor. They've had many discussions over the past year about cell phone records and all kinds of DNA, you name it. And if she is going to put forth the fact that Bill Thompson, or going to adopt someone's argument that Bill Thompson has created some sort of ethical dilemma here and may lose his law license and may throw this, make an appealable issue and later on in the future, she better think twice about something like that. He was mad at her, very mad at her.
100%.
Decided yet whether to allow this selfie of Kohberger or surviving roommate's testimony that she saw a man with bushy eyebrows leaving the home. Also still up in the air whether prosecutors can show the jury Kohberger's alleged Amazon purchases, which include a K-bar knife and sheath like the sheath investigators say was found at the murder scene, although the judge did signal he may allow it.
There's not a ground for exclusion.
In late 2022, Kohberger was charged with the murders of 4 University of Idaho students, Kaylee, along with Madison Mogan, Ethan Chapin, and Xana Kernodle. His lawyers say he has maintained his innocence. At the hearing, the attorneys also sparring over whether the jury should know about Kohberger's autism diagnosis. With Kohberger looking on, his attorneys saying it would be nearly impossible to put him on the stand without that context.
Brian's physical body is more stoic, how he sits in one place. And he will look at for a long time, and that means nothing. That's just how Brian is.
Now, as of now, it appears unlikely that Kohberger is going to testify on his own behalf. We did learn, however, that the prosecution does plan to call some of his family members to the stand. The judge suggested that he will ask the state to have them testify first so that they can then be there in the courtroom to support Kohberger if they wish for the remaining weeks of the trial, guys.
All right, Liz, thank you. NBC News legal analyst Danny Savalas joining us now.
We really don't need their legal analyst. The thing is, people are talking about Cy Ray, who is the defense's expert on cell phones. And perhaps the defense got the information from AT&T and the prosecution did not. Maybe the window opened to get it and it closed, and they got it before the prosecution. So the prosecution could not expertly defend against Cy Ray, who is a cell phone expert, former law enforcement, I believe, a detective. So he, although had all this information, spoke out against the prosecution. And that is the area, Mike, in which the judge got severely upset.
Yeah, because if there was some sort of Brady violation, meaning the prosecution had in their possession any sort of records that would indicate that there may be some doubt about Brian Kohberger's guilt, that's exculpatory evidence. They'd have to turn that over. In addition to that, they have to turn over anything and everything that they have to the defense in a timely manner. And so, and she even complained about the massive amount of information that she has gotten and how difficult it is to go through it all. And, she's had a year, to do this. So making allegations about the prosecutor's conduct, professional conduct, you better have some facts, dates, times, contact people swearing that they did send the records, that the records were created. You better have basically your own investigative file if you're going to, that you could show to the judge or later on to a board of inquiry regarding his fitness to practice law. If you're going to do something like that, the judge was mad about it. And I think Cy Ray, for whatever reason, why he put whatever he put into his record to give to Ann Taylor may not have been the best choice of words and has opened up a huge can of worms. And actually, it's going to hurt the defense more than it's going to hurt the prosecution in the end.
100%. Mike, I have a list of some of the things, and I'm going to go. I'm going to list them, and I'm going to go to you.
Okay.
The defense requested that no inflammatory evidence, for example, the words murder or psychopath, can be used to describe the killer's behavior.
Yeah, Bill, the prosecution witnesses, like the law enforcement, are not going to use words like that. They're more professional than that. If, however, they had interviewed a witness who used the word like psycho, like who would want to murder my friends? That person must be a psycho. If if a police officer recorded that on a form, as part of the record, that could be read into the record, because that would be, a statement made by a witness and they had recorded properly. But they themselves would not testify using those words to describe the situation.
Another thing, evidence of other wrongs, and it's described as 404B, known as prior bad acts. And obviously, if a defendant is on trial for something and has an arrest history, the prosecution cannot bring that up. But what the defense was listing here was not bad acts. In fact, they listed once he was pulled over in a car stop. I think it was a traffic stop on August 21st, 2022, in this vehicle, and he was driving the same vehicle. That's the point why this car stop was so important to the prosecution, that he was driving that white Elantra. So the defense tried to say they can't use that because it's a prior bad. It's not a prior bad act. He was never given a summons. He was just pulled over and questioned, and then he was let go. So the judge was sort of like, what are you talking about? How is this a prior bad act? So again, they're grasping at straws with some of this stuff.
Yeah, look, they're desperate. They're doing the best they can. The idea that getting pulled over by, I think it was actually a University of Washington police officer. Like, I think he was actually somewhat on the campus at the time and was pulled over by the Washington, the female officer. It's only there, and the prosecution will use it to show that Brian Kohberger was present on the University of Washington. He was driving a car that fit the suspect vehicle number one that we've heard so much about. And it was, as you could see on the video, a Hyundai. Nobody's in a white Hyundai Elantra, a fairly recent model. Nobody is going to think that has any connection with the fact that he may have killed. It's just there to show the jury that Brian Kohberger had a vehicle. It was a white Hyundai Elantra, late model, and he was there in the state of Washington, which is right on the border where Moscow, Idaho is, several months before the crime occurred. That's all they want to use it for.
100%. Fuzzy Doxy from the chat. Didn't the judge just confirm he's allowing the Amazon order? He did not confirm, but he is, you could see by his body language, he's leaning that way, because he asked the defense many questions like, well, first of all, the defense's argument is that this account, the whole family used it. And the judge simply asked, wasn't Brian's name on this account? And it seemed as that was in the affirmative. Yes. So the fact that perhaps, and who knows if the family had access to it, but that's their argument.
Right.
So it appears that the judge will allow this in, because why is it so important? Because if he ordered a K-bar knife, a K-bar sheath, and a sharpener, what was found inside the room with the victims, Kaylee Gonsalves and Madison Mogan?
Right.
The knife sheath with Brian Kohberger's touch DNA on it. That is the most important piece of evidence in this entire case. Do you think the judge is going to throw that out? And then to put even more of importance on this evidence is that later on, he tried to order another knife sheath, perhaps to replace the one that he left in the crime scene. So, yes, I believe that the judge, I don't think he's indicated that he's absolutely going to allow it, but it appeared that he was leaning that way, Mike.
Yeah, Billy, there was even a strange extended discussion with one of the other defense attorneys, and I apologize, I don't know her name. She had darker hair, and she was talking about Amazon and clicking. And the judge said, I think everybody knows that if you want to order something on Amazon, you click on the product, it goes into your shopping cart, and then you go check out. This is kind of strange conversation to have in a pretrial motion for a quadruple murder trial. And he said basically that he's probably going to allow that sort of business record to come in because business records are known to be, extremely accurate, and basically told the defense, you will have to just cross-examine on that. And you can bring up doubts about who you think may have had exclusive right to it, or is it a family account? There'll be somebody from Amazon, and you could talk about that. But to outright prohibit it, he doesn't look like he's going to do it. He's just told them that it's probably going to come in because it's so accurate. You'll have somebody there, and you're just going to have to do the best you can by cross-examining them, and that's it. I think that's exactly where he's going to go.
Absolutely. Ann Waters, Zorro. Was Brian's name on the charge card used for the Amazon order of the knife, sheath, and sharpener? Of course it was. Yeah, I would agree with you. Of course it was. Doesn't that answer the questions that anyone would have? So the defense is trying to say, because other family members, look, I have an Amazon account. Do my family members have access? I suppose they could get into it if they wanted to, but it's my account. And all the things that's ordered on it are my orders. So I think it's in a way, a little bit silly. Car Guy, who ordered that knife from Amazon and where is it? Car Guy, obviously it was ordered by Brian Kohberger. Where is it? He dumped it. He got rid of it. If you believe that he is the suspect, he is the perpetrator in this, he got rid of that knife, and he erred hugely by leaving the knife sheath in the crime scene with his DNA on it. And everyone, I just get crazy when I hear some of these content creators trying to explain away the touch DNA. They don't know what they're talking about, yet they're all experts on investigative genetic genealogy. That is the most powerful piece of it. I don't know how the defense is going to try to explain that away. I don't think they can. Mike.
Bill, we've been discussing DNA since the late 1980s, universally, in the early 1990s, and you were involved in some of those cases way back in the early 90s. It's beyond doubt. It's been proven time and time again that touch DNA, those few skin cells, that has been proven time and time and time again to be a reliable indicator when you upload it and you do the examination of the alleles and all kinds of other stuff. That's how you identify somebody. It's been used to identify people after 9/11, after the attack. It's been used many times in criminal investigations. And to top it all off, when they arrested him, they did a buccal swab, and it matched the DNA that they got from the knife sheath. So if anybody says, there was only a few skin cells, doesn't matter. Those few skin cells pointed to Brian Kohberger, and we know it because it was double checked when they did the buccal swab. So there's really no argument. I don't know what she's going to do. Maybe she could talk about what she was really going to do. And I think she pinned her whole hopes on accusing the FBI of committing a constitutional rights violation under the Fourth Amendment. She lost that big time. I think the ship has sailed on the DNA. I don't know what she's going to do right now to try to counter that, maybe by making some arguments with a defense witness, an expert witness on their own, to talk about the fact that the DNA might have been degraded or something like that. But she's stuck between a rock and a hard place right now with that DNA.
100%. Folks, this is Police Off the Cuff, real crime stories. If you like real crime, true crime from a police perspective, in the right place. And if you're not subscribed, hit that subscribe button. Help us out. Hit the like button. That helps with the algorithm. Share us with your friends and your family. If you want to contribute to us financially, we have a Patreon with 4 different levels. We also have a YouTube channel membership with 5 different levels. We appreciate you joining our channel, becoming part of the Police Off the Cuff family. From the chat, Tim M., I think you're referring to the Amazon order. Other people could have put it in the basket. Tim, if we believe that, and this is at best circumstantial evidence, right? Because he ordered a K-bar knife, because he ordered a K-bar sheath, because he ordered a sharpener, Does it necessarily mean he's the killer? No, it doesn't, does it? But it's pretty damn strong circumstantial evidence. And that's all I'll say, because this case has no eyeball witnesses that saw the perpetrator commit this crime. It has to be connected. Evidence has to be. Follow the dots, as we used to do as kids in coloring books, right? Follow the dots and follow the evidence. And either the jury believes, after they follow the evidence, circumstantial and other evidence, that Brian Kohberger is the killer, or they do not. And if they find that the evidence is powerful and strong, then they'll vote guilty. And if they find that it's not, even if it's one person, if the defense creates enough doubt, then he may walk. That's what we're discussing here today.
Sociopath or murderer in front of the jury.
For the state to come in and label Mr. Kohberger is very detrimental. It's inflammatory.
The judge said using the word murder is allowed, but he warned he will not tolerate having Kohberger labeled as a murderer outside of closing arguments.
And I will shut you down faster than you can imagine if I see that.
We intend to conduct our trial professionally.
Kohberger is accused in the stabbing deaths of University of Idaho students Kaylee Gonzalez, Madison Mosion, Xana Kernodle, and Ethan Chapin in their rental home near campus during the early morning hours of November 13th, 2022. The judge denied a motion by the defense to prevent overly graphic scene photos and videos to be shown to the jury.
These murders, whoever committed them, were brutal and were horrific. And so I suspect that the evidence will reflect that.
Kohberger's lawyers also want to exclude his online shopping history that reveals he bought a K-Bar brand knife 8 months before the killings. They argue it could be taken out of context. Investigators found a K-Bar knife sheath next to one of the victims.
But it's not a bad act to purchase things on Amazon.
If found guilty, prosecutors are seeking the death penalty. Jonathan Vigliotti, CBS News.
So there you have it. Yeah, it seems that the judge is going to allow the Amazon orders. I don't see, because that's a huge part of this, and it connects the dots to this case. And for those that think he should deny that, I don't know where you've been in this world. I don't know what court cases, what murder cases you've been following, because I think 99% of judges would allow this evidence in. It's so important. Mike.
Yeah, Bill, if there's some sort of Amazon history that he purchased an oil filter for his car, nope, it's totally irrelevant. The fact that he ordered a K-Bar knife, and it was told, and in the early part of the investigation, they said, the medical examiner said that it was a large hunting kind of knife. And then we found out that there was actually a knife sheath, a K-Bar knife sheath, which is a large knife used by the military. And so that is circumstantial evidence that he had a knife sheath. He had the K-Bar knife before 9 months or 8 months before the murders occurred. So it was in his possession. He had it. It's circumstantial evidence. And so that history reflecting his purchase of that thing is perfectly, A, it's business record, so we know it's reliable, and B, it's relevant because it answers the prosecution's assertion of what kind of large knife was used to kill these 4 kids. And that's it. There's no further argument over it. They're not going to talk about, what he bought, when he was 17 years old. No, what he bought within a couple of months of the killing, and what he bought was the kind of knife that was actually used in the killing. And part of that, what he purchased, was left there at the scene of the crime. And, oh, by the way, it has his touch DNA on it. No argument there.
Absolutely. AB from the chat, all they have against him is circumstantial evidence.
That's right.
AB, I will repeat for ad nauseum 1,000 times. Sometimes circumstantial evidence is extremely powerful. And what do I mean by that? It's extremely powerful when there's lots of it and you can connect it. Circumstantial evidence simply means from which inferences can be drawn. So let's make the most simple inference right here. A K-bar and knife sheath is found in the crime scene next to the body of Madison Mogen. On it is Brian Kohberger's DNA. 8 months ago, Brian Kohberger ordered a K-bar knife, a knife sheath, and a sharpener from Amazon. Do you not think that that's circumstantial evidence? Which both items are circumstantial. Do you not think that that's powerful? I mean, so when people just try to dismiss evidence, oh, that's circumstantial. Think about what you're saying. Think about what you're saying. How about the white Elantra that he was driving in on August 21st, 2022, that turns out to be the car, the model of the car that the killer was driving the morning of the killings. Is that smoking gun evidence? No, it's not. It's circumstantial. But do you see what I'm getting to? Do you see how it connects? Do you see how it becomes powerful based on the connections? Mike.
Yeah, people don't realize that very little evidence at a trial, at a criminal trial, is direct evidence. It's almost exclusively circumstantial evidence. Direct evidence would be if you had an eyewitness who could testify that they saw Brian commit these crimes, or that he made himself his own statements implicating him in the crime, or you have like a surveillance video of him actually committing the crimes. Other than that, even touch DNA is circumstantial evidence of him committing the crime, him participating in the crime. So circumstantial evidence is very, very strong if you put it all together and the jury makes the logical leaps that, oh, as you said, he had bought it's circumstantial evidence that he had the knife sheath and bought the knife sheath and the knife 8 months earlier. And one of those items, the sheath, was found with his DNA on it underneath one of the victims at the crime scene. That allows a jury to make the logical leap, make the logical inference that he possessed that knife. He is the killer. The same thing with a Hyundai. They saw a Hyundai on very blurry video driving around, getting the hell out of Dodge after that crime took place. And lo and behold, Brian Kohberger has a white Hyundai. We know that because we have him on videotape in August there in Washington State University driving a white Hyundai. It's all, some people say, oh, that's just a coincidence. It's circumstantial evidence coincidence for you. Let the jury decide whether they make the logical inference that Brian Kohberger was driving that getaway car. That's all.
Mike, one of the other things is that they talk about his family members testifying, and they called it a sequestration orders. Yes. So that because the family also wants to be in the courtroom. So the judge's idea, and he has to first query the prosecution as, who do you intend to call as a witness? And if you do intend to call them as a witness, the court wants to make sure they go on very early in the case so that they can be seated in the courtroom, which I think is a bit of a distraction, especially when someone testified and they're going to be in the courtroom. It's almost like going to see a play and have one of the actors sit in the audience after he's done with his scene. I think it's a little bit fugazi. What do you think?
Yeah, Bill, he's stuck between a little bit between a rock and a hard place. He's trying to do, what's right for both the prosecution and defense. And everybody should be able to have a loved one. If you're being accused of a crime, you should be able to have a loved one in the courtroom providing some sort of moral support for you, whatever. That's all. And he's got 2 sisters, a mom and a dad, and some of them will be coming there. And the judge, the prosecutor, Bill Thompson, has probably told the judge, who he would like to get onto the stand. And therefore, if, say, for instance, he's going to ask the father and one sister to be witnesses. Well, then the other sister and the mother could sit behind Kohberger, behind the defense, and offer moral support while the other 2 are sequestered. There's some sort of balancing act he's going to try to get the prosecution and the defense to agree to for just mercy's sake.
You know, the other thing that the defense is trying to sell is the autism spectrum disorder.
Right.
And one of the things, of course, that every jury is always looking at during a murder case is the defendant.
Mhm.
So she's trying to explain, you see how he sits? He sits very like stiffly and doesn't move. Apparently, Ann Taylor is claiming that is because of his autism spectrum disorder. But, then others may argue if he, in fact, they're looking for that defense autism spectrum disorder. And I don't know a lot about it. I'm not pretending. But do most people or any people, or what's the percentage of people that have this disorder that can also do the work in a PhD program?
Yeah, Bill, if he is on that some sort of spectrum, and I'm not a psychologist, or, I might be using words incorrectly, but if he is on some sort of spectrum, that spectrum is very wide. It encompasses tremendous variations in communication style, in intellectual ability, and, in integrating themselves with other people and talking to other people. She's looking, the thing is, she wants to interject this early on. And so therefore the jury won't take offense to his sitting there very stiffly, maybe staring. But the thing is, under normal circumstances, a judge would shut that down to say, look, if you counselor, as a defense attorney, are going to bring up some sort of perhaps mental health issue, you would have to claim that as a defense, but you're trying to claim it not as a defense because they don't allow like the insanity defense or anything like that in Idaho. You're trying to tell that to the jury and trying to get it in there without actually, getting an expert witness to talk about that, because that would be something that would be, if there was a conviction, and if there was then the second trial for the death penalty, that would be the proper place to bring it up. I don't know if the judge is going to allow any sort of statements by the defense to the jury to tell them that Brian has autistic spectrum behavior issues, unless she, in her case in chief, unless she has an expert witness that's going to say that that is a disabling kind of condition to have. He's very skeptical about this.
Deanna Robinson, thank you very much, Deanna. The diagnosis is for death penalty mitigation, not assertions of innocence.
Right.
Deanna, I think you're 100% right. However, I think that Ann Taylor also wanted to explain his physicality and how he sits and how he moves to, so that the jury doesn't think, look at him, he's a psycho, or he's a, So she wants to pre-explain that. But Deanna, you're 100% correct. The diagnosis of a death penalty mitigation, not assertions of innocence. You're 100% right. However, as I said, they're trying to throw as much at the wall as possible so that they cover almost everything that, that the prosecution could possibly bring forth. Look, the prosecution wants to put together a professional case. They don't want to get sensational. One of the things, and many of the things, I should say, not just one, I believe the prosecution has a lot more evidence we haven't even heard about yet. And there's all those who say, oh, we should have heard about it in discovery. Didn't we just find out about an amazing amount of evidence 2 weeks ago? So you don't think there's 3 more months to the trial that we could find out about evidence? Because don't forget, there was a gag order for a long time, right? So I wouldn't look. There's those saying that Kohberger's sister may have told law enforcement something. Could they now force her to testify? And with the statement she made to law enforcement, have her understand and say, did you in fact make this statement? How powerful would that be, Mike?
Yeah, Bill, if it is true that she made that statement and the prosecution wants to subpoena her, they could do it. And then she'd be sequestered. She'd be one of the people sequestered from the family. But the thing about all of these hearings is, and this is excellent for people in the public, is there was such a gag order that nobody knew what evidence that the police had. Now, every time that Ann Taylor tries to get another piece of evidence tossed out, we learn about it. So there's still, as you say, tremendous amount of evidence that we don't know about. We'll know about it at the trial, but we may hear about it earlier on if Ann Taylor tries to get it thrown out. We haven't heard anything about the results of the search of his Washington University apartment. There was some interesting things taken. She hasn't yet made a motion about those objects. We'll see, and we'll know what they actually are, and then we'll know that they are detrimental to his case. But this is good. This allows the public to see for the first time over the course of 2 years how much evidence and the type of evidence that they have against Kohberger.
Deanna Robinson, again, thank you. This is a gem. In the hearing yesterday, Ann Taylor mentioned she would be picking up more discovery yesterday. Yeah. So, yes, that's a gem. Thank you so much. With the cell phone evidence and the expert, Cy Ray, he was a brilliant, in one of the hearings, he was a brilliant witness. However, the prosecution didn't have a chance to go back at him because they didn't have the evidence that he was referring to. They didn't have their own expert to counter what he said. So all the people that were saying, oh, this is a slam dunk, Kohberger is getting off. Look, to every offense, there's a defense and vice versa, And just like so many people try to absolutely dismiss the touch DNA, it just drives me out of my mind. People trying to dismiss that in the same way that people try to say Cy Ray's evidence is a slam dunk. No, the prosecution hasn't even had a chance to counter that evidence with their own expert. Let me play some of this from Law and Crime.
Will come into evidence. Exceptional, what we mean. And we mean when it's over the top, when it's unnecessary, when it's going to inflame the passions of the jury, and that tips the scale of relevance. We don't know exactly how the state's going to try its case. We do know there are over 13,000 photographs, hundreds of hours of videotape, and many, many witnesses who the state will call to testify. We believe that it is imperative that we have an order to prevent the case being tried in a way that presents inflammatory evidence and appeals to emotions for the jury.
What the hell is inflammatory evidence? This is a murder case, a quadruple murder case. What is inflammatory, Mike? Are pictures of the victims? Is that inflammatory? Is it?
Bill, she mentioned, we talked about using the words like psychopath and murderer, and the judge said, then Bill Thompson said, look, our witnesses, our police witnesses are not going to talk like that. All evidence that is introduced by, in this kind of case, a criminal case, all evidence that is introduced by a district attorney in order to convict a criminal defendant is prejudicial. All right. It's prejudicial. It's supposed to be prejudicial because it's trying to prejudice that person, that defendant's penal interest. OK. And when the defense introduces evidence against the prosecution witnesses, that is considered also the exact same thing. It prejudices the prosecution's case. All evidence that is brought into court by the prosecution or defense is trying to prejudice the other side's standing. And that's perfectly normal. What is not going to be allowed is anything that is inflammatory or overly prejudicial. So if there is, 25 hours of videotape of the crime scene in all its gruesomeness, the judge might say 2 hours. If there's 13,000 crime scene pictures, he's going to say, 500, so that we don't go overboard with it. But she's trying her best to limit the amount of gruesomeness and say it will inflame the jury's passion. Well, you know what? She's doing her best, and she has to do these sorts of things. Good luck, because if there's 50 photos or 500 or 5,000 shown to the jury, they will get the message about how horrific these murders were. She's doing what she has to do. She's doing her job of zealously advocating. That's her ethical obligation. But he probably will limit. Obviously, will limit. The judge will probably limit the amount of evidence that he feels is enough and not anything more, because that may actually be overly prejudicial. And he knows no matter what, there's going to be an appeal on this case, and he wants to make a ruling that is favorable and fair, so that if she does make an appeal, that the passions of the jury were allowed to be inflamed unnecessarily by the prosecutor, then she may have grounds for a retrial. So he's going to be very careful, but there's no way that there won't be any sort of prejudicial limitations on prejudicial information coming in. It's just the excessiveness may be cut down.
Mike, one of the things I just like to say, let's not forget that this trial was granted a change of venue, right? So this trial is not in Latah County in the town of Moscow where the crime occurred. It is in Boise, Idaho. So that was one victory for the defense. However, I also think by doing that, the defense lost a very sympathetic judge. I felt that Judge John Judge was much more sympathetic to the defense, and not, Judge Hippler, I think, is just a stern, by the rules, by the law, and he's going to decide based on the law, because no judge wants to be reversed on a death penalty case. No judge wants any mistakes, procedural mistakes. No judge wants to make a mistake on the law. So I think the prosecution has a damn good judge, but so does the defense. But he's not going to put up with any bullshit, because the defense is really bringing a lot of crap in here that he rightfully is questioning. Like, what, are you kidding me? Like, imagine saying, well, they can say it, throw out the DNA. Throw out the DNA. Could you imagine a judge that would do that? That I'm going to throw out because they're alleging, the defense is alleging that the FBI violated not the law, protocol of a private company. So based on the protocol of a private company, do you think the judge should throw out the baby with the bathwater?
Not at all. Violating a user agreement or protocol does not equate to a Fourth Amendment constitutional rights violation of Kohberger. Kohberger has no standing to assert a Fourth Amendment violation for the way his DNA was used by a company, by the FBI, or how it was used, or what examinations were used to determine whose DNA was, the actual analysis. The only issue, and like the judge said, Hippler said like a month ago, was, did they get a search warrant for the home? Yes, they did. Anything that they found at 1122 Kings Road that is taken, and they could analyze it. You're not going to sit there. If you want to sit there and argue the type of tests that were done to determine DNA, you better get your own expert witness. But a judge is not going to sit there and say, if the FBI violated a company's protocol, that's a violation of Kohberger's right to privacy under the Fourth Amendment. No way, no how. Even Judge John Judge may not have gone for that one. But Judge Hippler here, he's the kind of judge you want to have on this case.
100%. Deanna Robinson, I'm enjoying your comments, Deanna. Ann Taylor has decades of experience in trial litigation, decades. I don't doubt it. I'm not saying she's not a good jurist. She's not a good attorney. I think she is. Yeah. But having said that, some of the things that she's bringing up in motions are a stretch. They're a stretch. They're stretching because they have no basis in case law. And to argue that the DNA should be thrown out, no case law. What she's arguing is that they violated the protocols of a private company that does investigative genetic genealogy and builds these family trees for the FBI and tests the DNA. That's the argument. Because, some of these companies that do these investigative family trees don't allow the use by law enforcement. However, the addendum is that law enforcement can get access via subpoena. So if they give the right legal document to access some of the genetic genealogy in these companies, they're allowed that. So if a judge would say, oh yes, I'll throw that out because, and I don't know which company did it. Let's just say 23andMe. Okay, let's throw out the evidence because they violated the company policy of 23andMe. That's not the law, Mike.
Yeah, Bill, they collected the DNA from that knife sheath pursuant to a search warrant, a crime scene search warrant. That's all the law requires. And they did it, and they did it right. So therefore, how they do the analysis, maybe there's several different tests they could use. Let the defense attorney with an expert on the stand argue in front of the jury that maybe the analysis of the touch DNA was wrong. But to sit there and say the fact that the FBI got the DNA and it was gotten through a search warrant at the crime scene search warrant, that it is therefore now a constitutional rights violation because they didn't follow established protocols with the company, that doesn't make any sense whatsoever. Makes no sense.
Absolutely not. Let's go back to law and crime here.
All right. The standard for motions in limine, which I'm about to set forth, applies to most motions today that we will address today. And I don't intend to repeat this with each motion, but for the record, let me go through it once. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. All evidence, all relevant evidence is admissible except as otherwise provided by the rules of evidence or other applicable laws of the court or of the state. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading of the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The question of whether evidence is relevant is a question of law to be reviewed de novo, while the decision to admit relevant evidence is reviewed for an abuse of discretion. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with the legal standards applicable to the specific choices available to it, and reach its decision by the exercise of reason. So my concern with the motions is not the substance of them in the sense that I think it's appropriate to highlight those issues that everybody should be cognizant of. It's in fashioning an order that has any real meaning because of the breadth and lack of specificity of the motions. With respect to the use of term psychopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label. Absent evidence, competent forensic evidence, if you will, qualified expert evidence, and I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things, but for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms where they're equivalents. Happens where you believe a door has been opened before launching into that in front of the jury, you are also required to bring that to my attention outside the presence of the jury. with respect to the term murder, well, let me start with the term murder. So I don't, obviously the jury is going to be charged with what the charge is or our charges are in this case, which include first-degree murder. I don't think there's any problem in using the term murder as it describes the charges and the allegations. Testimony or statements by counsel or by others that the defendant is a murderer or committed murder, I think would be essentially argumentative in nature at this point. I will tell you that the one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it, because I'm serious about not arguing in your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant committed murder prior to the closing. Now, certainly the allegation that the defendant committed murder is going to be relevant and probably appropriate in opening statements, perhaps even in voir dire. But apart from that, if you're intending to go there, you need to bring that to my attention outside the presence of the jury.
You know, Mike, one of the things I wanted to talk about, and you see how reasonable this judge is and how soft-spoken, but yet stern and strict, and to both sides. He's trying to take it right down the middle. But, and I want you to explain this since you are an attorney. The defense has indicated that they're going to produce an alternate, or they leave it open, they're going to produce an alternate suspect. That is easier said than done, because if you produce that alternate suspect, you must name him or her. So that may just be strategic in nature, and they don't really intend to do that. Your thoughts?
Yeah, Billy, you know, they could always, at the end of the trial and closing arguments, say, you know, there's and, you know, criticize the police and say they didn't review all of the possible suspects that they got tips on. But the judge did admonish her that if you were going to say that and bring up to the jury that you have an alternative theory to the case, when she then, you know, in her case in chief, when she stands up and says, Your Honor, the prosecution has already made their case. Now we, the defense, are going to make our case. That's her case in chief. If she wants to say there's an alternative theory and there's an alternative killer, you're going to say that. The judge said, you better be prepared to name a name. You can't just say it's out to throw it out there and just leave it hanging. You better say it's a name, say a name, and you better have a good faith reason for giving that name. And that puts her in a strange position, because if she does name somebody, Joe Smith from, you know, Moscow, Idaho, is probably the killer. If you say that, you're opening yourself up to like perhaps a defamation lawsuit by that person. So he's telling her up front, you know, if you're going to say that you have an alternative theory and this is probably the killer, you got to name that name to the jury and put it out there and support it with some sort of evidence that this person themselves drives a white Hyundai. This person themselves is a hunter and has a K-bar knife. You just can't, you know, throw that out there. You better build a foundation for that argument, a reasonable person foundation for that argument. So I don't think she's going to go there and in her case in chief. I think probably she's just going to allude to the fact that, you know, who was not, how many people were not investigated when she does her cross-examination of prosecution witnesses, and perhaps in her closing arguments, she could say that there are probably people out there who were never investigated, without naming them, just throw it out there at the very, very end, say, they never, investigated every possible person. But she has to be careful.
One of the most important things in this case, of course, is the car. The car is usually important because if you recall this case in the very beginning, before there was even a perpetrator named, it was very early on. It was maybe, this occurred on the 13th. It was maybe on the 16th or the 18th. They mentioned a white Hyundai Elantra. And they mentioned it. And what you see on the screen right now is the times on the morning of 11/13/2022 that the white Hyundai Elantra was seen, taken by different video cameras in the vicinity of 1122 King Road. Now, they were looking for this white Hyundai Elantra.
Right.
And at some point, there may have been a nexus to the car and finding a car like that on Washington State University campus by a security guard. I think he found 2 Hyundai white Elantras. And the one, of course, known as car number 1 now, belonged to Brian Kohberger. And that is how he became a suspect. And there was no probable cause at that point. He became, I'll use the TV language, a person of interest.
Right.
He became a person of interest. Then they start looking into, where was that car? Was there a car like that on November 13th? Look, you see the times prior to the murders. And it was spotted on different video cameras in the vicinity of 1122 King Road. And when they did more investigation, they were able to spot the car going back on the roads leading back to Washington State University. Thus, we hear the alibi by Ann Taylor in the defense that he likes to go out stargazing and driving around at 4 a.m. when it's 10 degrees below zero and just go look in parks and stargaze. So hard to explain, though, when you connect the dots and the car is in the car. But again, we cannot identify the driver, can we?
No.
So this is, again, and I'll use the word, circumstantial evidence from which inferences are drawn. However, we connect the dots to Washington State University, and this car belongs to one Brian Kohberger. Mike.
And they have Brian Kohberger's white Hyundai leaving Washington University campus, like, an hour or 45 minutes, maybe an hour and a half before they think the murders occurred. And they connect out with the cell tower, indicating that he had turned off his cell phone shortly after leaving the university. And about 5:25 or something like that, I can't remember the exact time, they have video of him entering the University of Washington campus, his car again, and soon after that, his phone comes back on. It's turned back on. So it matches perfectly with, and so that makes it that much more, circumstantially that much more likely that he is the person, he is the suspect. But you're right. In the beginning, they had a few things, and by analyzing it, they put it all together, and circumstantially, they have Brian Kohberger as a suspect, and then you have the touch DNA. But that car alone, even though you don't have a picture, a clear picture, because the security cameras were not, didn't have high resolution pixels, they have the car, and you can tell it's a car that doesn't belong to somebody living in Washington or Oregon, because it only has one license plate. He later on, after the homicides, he then re-registered his car to have 2 license plates, when he changed his address. But at the time of the homicides, there was only one license plate. And so therefore, if there was any other white Hyundais owned by anybody in that part of Washington or that part of Idaho, they would have had two license plates on it. So even though doesn't seem like a lot to a lot of people, it is excellent circumstantial evidence.
AB from the chat, car model is common. There were thousands of white Elantras registered in the area. This doesn't prove it was his. We have said that. And I ad nauseum, I've been describing what circumstantial evidence is,
right,
from which inferences are drawn. And it just so happens that a car like this with one license plate that happens to be registered to one Brian Kohberger at Washington State University was seen in the vicinity of 1122 King Road. You can see those times right there. 4:07. That's right before the murders. 4:07 a.m. And you can see other times that it was caught on video cameras. 3:30, 3:35. I can't. It's small. 3:38, 3:40.
Yeah.
Powerful evidence, I think. Powerful circumstantial evidence, right? Which also gives an indication to law enforcement that he was hunting, wasn't he? He was doing a recon. I use the word reconnaissance. He was reconning the crime scene. I want to get to this right away because this is one of the biggest things that the defense wants to be thrown out, and it's the 911 calls from inside the house.
55 a.m. 42 seconds, November 13, 2022.
911 location of your emergency.
Hi, something is happening. Something happened in our house. We don't know what.
What is the address of the emergency?
1122.
What is the rest of the address?
Oh, Kings Road.
Okay. And is that a house or an apartment?
It's a house.
Can you repeat the address to make sure that I have it right?
I'll talk to you guys. We live at the White, so we're next to them.
I need someone to repeat the address for verification.
The address, 1122 King Road.
And tell me exactly what's going on.
One of the roommates is passed out, and she was drunk last night, and she's not waking up.
Okay.
Oh, and they saw some man in their house last night. Yeah. Hi, this is
And are you with the patient? Okay, I need someone to keep the phone, stop passing it around.
Can I just tell you what happened pretty much?
What is going on currently? Is someone passed out right now?
I don't really know, but pretty much at 4 a.m.
Okay, I need to know what's going on right now if someone is passed out. Can you find that out?
Yeah, I'll come. Come on, Bethany, we gotta go check. But we have to. Is she passed out? She's passed out. What's wrong? She's not waking up.
Okay, one moment. I'm getting help started that way.
Okay, thank you.
Pretty damn dramatic. Yes.
Okay, and how old is she?
She's 20.
20, you said?
Yes, 20. Here to
Okay.
Hello? Hello?
Okay, I need someone to...
All right, so we get the point here. The defense, they want this 9/11 call thrown out. And there's another piece of evidence that I don't see the judge throwing out. What do you think, Mike?
Yeah, they're not going to throw it. The judge is not going to throw it out completely. He may allow some redactions because some of it is confusing. And so he may do that. And he had mentioned that not every, the prosecution argued it should all come in, every bit of it, because it's all present sense impression. But the judge said he's going to make a ruling later on, and right before the trial or as during the trial, he may tell them there's certain things that they cannot, the jury won't have access to. But the fact is that most all of it will come in. Most all of it will come in before the jury. Just a few things may be redacted, or the judge might throw it out because it's inconsequential. It may be confusing to the jurors or something like that. But it will almost all of it will almost assuredly come in.
100%. I want to play just a little bit of this from Law and Crime.
Viewed the numerous videos that were collected and have had conversations with other officers, and they go on to say that. A review of camera footage indicated, and this is where that white Hyundai Elantra comes into play. A review of camera footage indicated that a white sedan, hereafter suspect vehicle 1, was observed traveling westbound in the 700 block of Indian Hills Drive in Moscow at approximately 3:26 a.m. and westbound on Steiner Avenue at Idaho State Highway 95 in Moscow at approximately 3:28 a.m. On this video, it appeared suspect vehicle 1 was not displaying a front license plate. At this point, they didn't know it was the vehicle that we now know, the white Hyundai Elantra. This is how they first were able to identify it. A review of footage from multiple videos obtained from the King Road neighborhood showed multiple sightings of suspect vehicle 1 starting at 3:29 a.m. and ending at 4:20 a.m. Remember the timeline of when they think these murders occurred. These sightings show suspect vehicle 1 makes an initial 3 passes by the 1122 King Road residence and then leave via Walenta Drive. Based off of my experience as a patrol officer, this is a residential neighborhood with a very limited number of vehicles that travel in the area during the early morning hours. Upon review of the video, there are only a few cars that enter and exit this area during this time frame. Again, this is also important because remember, he is charged with first-degree murder. There is a level of premeditation and planning to this. Keep this in mind as we hear all this. Suspect vehicle 1 can be seen entering the area a 4th time at approximately 4:04 a.m. It can be seen driving eastbound on King Road, stopping and turning around in front of 500 Queen Road, number 52, and then driving back westbound on King Road. When suspect vehicle 1 is in front of the King Road residence, it appeared to unsuccessfully attempt to park or turn around in the road. The vehicle then continued to the intersection of Queen Road and King Road, where it can be seen completing a 3-point turn and then driving eastbound again down Queen Road. Suspect vehicle 1 is next seen departing the area of the King Road residence at approximately 4:20 a.m. at a high rate of speed. Suspect vehicle 1 is next observed traveling southbound on Walenta Drive. Based on my knowledge of the area and review of camera footage in the neighborhood, that does not show suspect vehicle 1 during that time frame. I believe that suspect vehicle 1 likely exited the neighborhood at Palouse River Drive and Conestoga Drive. Palouse River Drive is at the southern edge of Moscow and proceeds into Whitman County, Washington. Eventually, the road leads to Pullman, Washington. Pullman, Washington is approximately 10 miles from Moscow, Idaho. Both Pullman and Moscow are small college towns, and people commonly travel back and forth between them. We talked about this before when he was ultimately apprehended, the connection, the geographical distance between his university and where these murders occurred. I'm going to continue on. Law enforcement officers provided video footage of suspect vehicle 1 to forensic examiners with the FBI that regularly utilizes surveillance footage to identify the year, make, and model of these unknown vehicles. The forensics examiner, and they go into the forensics examiner's background and experience. After reviewing the numerous observations of suspect vehicle 1, the forensics examiner initially believed that suspect vehicle 1 was a 2011-2013 Hyundai Elantra, but upon further review, he indicated it could also be a 2011-2016 Hyundai Elantra. As a result, investigators have been reviewing information on persons in possession of a vehicle of this type. Investigators were given access to video footage on the Washington State University WSU campus. This is how they were able to connect the car to Kohberger. If we have some more time, I'd like to get into it before we take our break. So let me do this real quick. Okay, so we're not going to take breaks. I'm going to continue to go forward with this. A review of that video indicated that at approximately 2:44 a.m. On November 13th, 2022, a white sedan, which was consistent with the description of the white Hyundai Elantra known as Suspect Vehicle 1, was observed on WSU surveillance cameras traveling north on Southeast Nevada Street at Northeast Stadium Way. At approximately 2:53 a.m., this is again before the murders, a white sedan, which is consistent with the description of the white Elantra, known as Suspect Vehicle 1, was observed traveling southeast on Nevada Street in Pullman, Washington, towards SR 270. SR 270 connects Pullman, Washington to Moscow, Idaho. The camera footage from Pullman, Washington was provided to the same FBI forensic examiner. The FBI forensic examiner identified the vehicle observed in Pullman, Washington as being a 2014-2016 Hyundai Elantra. At approximately 5:25 a.m., this is after the killings, a white sedan, which was consistent with the description of Suspect Vehicle 1, was observed on 5 cameras in Pullman, Washington, and on the WSU campus cameras. The first camera that recorded the white sedan was located at 1300 Johnson Road in Pullman. The white sedan was observed traveling northbound on Johnson Road. Johnson Road leads directly back to West Palouse River Drive in Moscow, which intersects with Conestoga Drive. I mentioned those streets before. The white sedan was then observed turning north on Bishop Boulevard and northwest on SR 270. At approximately 5:27 a.m., the white Elantra was observed on cameras traveling northbound on Stadium Way at Nevada Street. They go on to talk a little bit more about where it goes. They provided a map showing what the campus looks like and kind of what the area looks like. They go on to say on November 25th, 2022, MPD, Moscow Police Department, asked area law enforcement agencies to be on the lookout for white Hyundai Elantras on the area. On November 29th, 2022, at approximately 12:28 a.m., Washington State University police officer Daniel Tiengo queried white Elantras registered at WSU. As a result of that query, he located a 2015 white Elantra with a Pennsylvania license plate, LFZ 8649. This vehicle was registered to Brian Kohberger, and he resides at 1630 Northeast Valley Road, apartment 201, Pullman, Washington. You have just seen how they were able to link the car to the defendant. The same day, at approximately 12:58 a.m., WSU officer Curtis Whitman was looking for white Hyundai Elantras and located a 2015 white Hyundai Elantra at 1630 Northeast Valley Road in Pullman in the parking lot. 1630 Northeast Valley Road is an apartment complex that houses WSU students. Officer Whitman also ran the car and returned it, and it returned back to Kohberger with a Washington tag. This is where now you're going to see how they matched up the description from one of the roommates to the license. I reviewed Kohberger's Washington State driver license information and photograph. This license indicates that Kohberger is a white male with a height of 6 feet and weighs 185 pounds. Additionally, the photograph of Kohberger shows that he has bushy eyebrows, which again is what was indicated by one of the surviving roommates. Kohberger's physical description is consistent with the description of the male DM, the male that DM, again, the pseudonym used for one of the surviving roommates, saw inside the King Road residence on November 13th. Further investigation, including review of Lake County Sheriff's Deputy CPL Duke's body cam and reports, showed that on August 21st, 2022, so this is months before this happened, Brian Kohberger was detained as part of a traffic stop that occurred in Moscow, Idaho. This was by Corporal Duke. At the time, Kohberger, who was the sole occupant in the car, was driving a white 2015 Hyundai Elantra with Pennsylvania plate LFZ 8649, the one I just mentioned. During the stop, which was recorded via a law enforcement body camera, Kohberger provided his phone number, and then they don't actually list the phone number, they redact that. Investigators conducted electronic database queries and learned that the phone number, the phone is a number issued by AT&T. Now, so from now on, his phone is going to be identified as 8458 phone, 8458 phone. On October 14th, 2022, again, before the killings, Brian Kohberger was detained as part of a traffic stop by a WSU police officer. Upon review of the body cam and report of the stop, Kohberger was the sole occupant and was driving, again, the white 2015 Hyundai Elantra. On November 18th, this is after the killings, according to Washington State licensing, Kohberger then registered the 2015 white Elantra with Washington, and it later received a new plate of CFB 8708. That's because the license was about to expire. Prior to this time, the 2015 Elantra was registered in Pennsylvania, which does not require a front license plate to be displayed. Based on my own experience in communication with Washington law enforcement, I know that Idaho and Washington require front and back license plates to be displayed. Investigators believe that Kohberger is still driving the 2015 white Elantra because his vehicle was captured on December 13, 2022 by a license plate reader in Loma, Colorado. Kohberger's Elantra was then queried on December 5, 2022 by law enforcement in Hancock County in Indiana. On December 16th, at approximately 2:26 p.m., surveillance video showed Kohberger's Elantra in Albrightsville, Pennsylvania. The sole occupant of the vehicle was a white male whose description was consistent with Kohberger. Kohberger has family in Albrightsville, Pennsylvania. Based on information provided on the WSU website, Kohberger, and I went through this already, where they went into his background and how he did that Reddit survey. Now let's go into the cell phone data. The cell phone data is always critical. So as part of this investigation, law enforcement obtained search warrants to determine cellular data devices that utilize cellular towers in close proximity to the King Road residence on November 13th, 2022, between 3 a.m. and 5 a.m. Anybody who follows the Law and Crime Network knows cell phone data can track someone's location in pivotal points at important times. So what did it show here? This is interesting. After determining that Kohberger was associated to both the 2015 white Elantra and the 8458 phone, investigators reviewed these search warrant returns. A query of the phone in these returns did not show the phone utilizing cellular tower resources in close proximity to the King Road residence between 3 a.m. and 5 a.m. So the cell phone data doesn't show that he was there or was using that phone near the residence. But that is only part of the story. Based on my training experience and conversation with law enforcement officers that specialize in the utilization of cellular telephone records, individuals can either leave their cellular telephone at a different location before committing a crime or turn their cellular telephone off prior to going to a location to commit a crime.
Very, very interesting. Hang on a second. Let me remove this. So, I mean, again, we could say it's circumstantial evidence, isn't it? Does anyone listening to this not think that that's powerful? The circumstantial evidence? I mean, yes, it would have been more powerful if his cell phone would have pinged towers right near 1122 King Road at the time of the murders. However, that can be explained, that he turned his cell phone off. So, folks that are listening, and again, you know, Brian Kohberger is innocent until proven guilty. And our job here is just to present you with the evidence and to talk about the hearing that's going on and the motions and all of that stuff that the defense is trying to get some of this evidence dismissed. Mike, we went over a little over what I thought we would do today, but it was really interesting. I think it was a great show where you presented a lot of great information. Your final thoughts, Mike?
Bill, for anybody who's listening and anybody who's not sure about the importance of circumstantial evidence or the power of it, you know, just remember most all evidence used in a criminal trial is actually circumstantial evidence. And remember, if Brian Kohberger is truly innocent, if this is truly a big misunderstanding or the police are framing him, he absolutely has the right to get up on the stand at the end of his trial and say his piece. So, you know, just remember that those are all the possibilities that he has. So don't forget, we give the evidence as we see it through the lens of policing and experience, and be careful of the content creators that you access, because a lot of them don't really have any experience whatsoever.
100%. Folks, thank you so much for tuning in today. I thought it was a really interesting show, if I might say myself. I enjoyed doing it. I enjoyed presenting it with my buddy here, Professor Mike Giri. Again, thank you so much for tuning in. I'm Bill Cannon from Police Off the Cuff. Have a great day. God bless everybody.
One episode just ain't enough.